Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
This to the stage. Hello, I am the loud little ducky. Today we are going to go over the Woodnick response to wanting a new judge. Didn't want that yet. Wanting a new judge, and we are also going to go over Congress's motion for a new trial and to vacate the judgment and all of that. So let's start with that. You can like, comment, subscribe, share this video out. And our prayers go out to Trump's family and the ones that have been injured or also deceased from the rally, Trump rally earlier today. We are not going to discuss it, but it is a sad situation, whether you like them or not. You should never want that for anybody. We're going to add this. Let's also change the background to this. Okay. So, Woodnick's response for a new judge. Woodnick law in the Superior Court of the state of Arizona in and for the county of Maricopa. I always like how sometimes, like, it's so different sometimes wherever state they're from. At the top, you would think it would just be one way, but it's not. But it is in the matter of Owens v. Echard, and this is the response to notice of change of judge for cause assigned to Honorable Judge Mata and the presiding Honorable Judge Rhonda Fisk. Pursuant to Rule 6.1 D1, Respondent Clayton Echard hereby responds to Petitioner Laura Owens' notice of change of judge for cause, filed July 8th, 2024, and requests the court deny the notice as untimely. Respondent objects to salacious allegations contained in the petitioner's filings, gross misrepresentations, reckless incendiary comments, impugning the integrity of Judge Mata. See footnote 1. Counsel comments that Judge Mata was trying to impress her father. Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. No. Like, it's just so, it's like, why would you put that in a court document? Why? Like, it seems like he's trying to call Judge Mata a pick-me girl or something, which is probably so far from the truth. But the court need not reach the sufficiency of grounds because the notice is irredeemably time-barred and inappropriately invoked. Response Memorandum. Neither ARS 12409 nor its implementation via Rule 6.1 permit change of judge by affidavit of bias and prejudice after final trial. This is kind of where we stopped in the other stream because I didn't know that I had sound on the other one. So I just stopped it and restarted. But what I was saying is that I I thought that was kind of odd to ask for a new judge after a trial or a hearing because usually you can't do that once the hearing's been held and evidence has been seen, and especially with judgments already being handed down. 1. History of common law preemptory challenge. Arizona long acknowledged a right to change judges upon filing an affidavit of reasonable belief of bias or prejudice. See Stevens v. Stevens, which is a 1915 case. Allen v. Allen, which is a 1919. Early territorial statutes codified this right, and it was later implemented by procedural rules. See footnote 2. Civic Code 1913-500 can be traced with functionality, identical language through to ARS 12409 via the 1955 reorganization of laws into the Arizona revised statutes. See Brush Wellman Incorporated, Lee, which is an Arizona case from 2000. Although the Supreme Court has refined the procedures, the right itself is not sourced from the procedural rules. 2. Time limit for challenge via affidavit of bias and prejudice. The relevant language of ARS 12409b5 as it exists today is functionally identical to the 1913 Civil Code provision, which itself gave form to its common law antecedent and an 1887 territorial code provision. The court must reassign the action to another judge to preside at the trial of the action upon a party filing an affidavit showing cause to believe an actual belief that she cannot obtain a fair and impartial trial on account of a biased judge. See Stevens at 309, Wardock and Farley, which is a 1963 case. The language of the statute in 1915 was in all essential identical to the language of the statute today. Brushwell Incorporated Supra. Klondike decision reiterates the change of judge upon a timely filed affidavit works automatically. Klondike at 193. As to filing the affidavit at time, Klondike approves and expands on Stevens and Allen, both of which endorse strict limits to file before final trial. Stevens held that the filing 1 day before trial did not waive the right, but Allen held that a party filing the affidavit after trial had already commenced did not act with diligence sufficient to require the trial court to take cognizance of her application. Allen at 72. The party is not permitted to wait until he sees which way the decision is going to go before deciding whether to stay with or try to eliminate the judge who is hearing the matter. Nor is he permitted to wait until the judge has heard evidence on the merits, which will have to be resubmitted if another judge is substituted. West v. Superior Court, Arizona, 1968, emphasis added. So even if the first one isn't true, because Gingras is going to say, no, I emailed her about this prior to her decision. So I didn't wait for her decision to see if I liked it or not. So he's going to spew that, which I think he already has. But Woodnick is saying, even if there was that, the fact that the judge heard the evidence on the merits of the case does not permit somebody else to come in. And he didn't raise it at any point prior to. Petitioner's reading of Del Castro v. Wells is not supported. Procedural rules implementing ARS 12409, like ARS 42, did not create a separate and distinct remedy from the statute. It simply modified the procedures orders to be followed. Brush-Wellman Incorporated v. Lee, Arizona, approximately 2000. Del Castillo expressly rejects the notion that procedural rules implementing 12409 create separate and distinct remedies. Del Castillo, Arizona, 1974. In fact, Rule 6.1 increases the burden by requiring the affiant to prove the sufficiency of cause to believe bias by an objective standard, i.e., the affidavit itself must have substantive merit. And we know that all of Gingras's affidavit is based on speculation and rumor and and a hope and a dream that this is going to actually happen and that those things are true. It's not. They don't have evidence to show that any of this is true. It does not expand statutorily rights or create a new one. The court must simply reject the notice as to Echard because it was filed after final trial and final judgment under Rule 78. Wherefore, respondent requests the following: an order rejecting the notice of change of judge, an order granting leave for respondent to file a supplemental affidavit of attorney's fees and costs, entering any further order necessary and appropriate considering Rule 8.2a of the Arizona Rules of Professional Conduct. Respectfully submitted this 11th day of July 2024. Woodnick signed it and sent the copies where they were supposed to go. So Woodnick doesn't even get into it with Gingras. He's like, I am not even going to argue with your BS that you put in your filing on bias and wanting a new judge. He's like, I'm going to argue the law. I'm not going to get into all that. If you want to sit there and throw daggers at a judge, then you go right ahead. He's like, I'm not stooping to your level. I'm just going to tell you, Mr. Law, that thinks he's right about every single thing. I'm just going to recite law to you that doesn't back you up. He could have gotten into all the other things. And he's like, I'm not even going to address the stupidity. I'm just going to tell you why you're wrong. And major props for that, because he's not stooping to Gingras' level, which he never has, but he's showing true professionalism here, which Gingras lacks. All right. Now we are going to get into Owens' motion to vacate trial. And this guy, imagine they both had brown hair, but they kind of look like Gingras and Owens with her fake tummy. She wants a new trial. So let's start the stupidity. All right, so that's going to be 13. Okay. All righty. Let's get into that. I've got to start learning to timestamp. I'm going to learn that. That is on my to-do list, is to learn timestamp for later. So here we have Gingras files for the petitioner Owens in the case of Owens Echard in Maricopa Superior Court, State of Arizona. Motion to vacate judgment. Motion for new trial. Alternatively, motion to alter, amend judgment. Motion for leave to exceed page limits assigned to Honorable Judge Matta. I don't think Matta's going to want to hear any of your BS. She ruled on it. The end. Not doing anything else. But let's see what he wants to happen. I have not read this yet, so I had to wait to go over it for the first time with y'all, so we have real true reactions. Pursuant to Rules 83 and 85, Rules of Family Law Procedure, petitioner Laura Owens, Laura or petitioner moves for an order vacating judgment entered in the matter on June 17, 2024, filed June 18, 2024, the judgment. Good movie title. In addition, Laura further seeks a new trial pursuant to Rule 83B, as well as an order or as other relief as stated herein. Introduction. As the docket in this case reflects, on July 8, 2024, Laura filed a notice of change for judge for cause after her case was over. As the date of the instant motion, the notice remains pending. Per Family Law Rule 6.1D4, although this matter currently remains assigned to the notice judge, Honorable Julie Matter. If the matter is reassigned, the present motion will be decided by a new judge who is not familiar with the extremely complicated procedural and factual history of this case. At the same time, while this matter is temporarily on hold due to the notice of change of judge, the 25-day time limit to bring a motion under Rule 83C1 continues to run. The deadline, which expires on July 13th, making the last day July 15th, 2024, also necessarily controls Laura's time to appeal, and it may not extend by stipulation or court order. Accordingly, although she would prefer not to do so until the issue of disqualification is resolved, Laura has no choice but to bring the instant motion. Okay, well, keep bringing it. I don't think it's going to help. A, factual history. Because this motion may ultimately be decided by a new judge who is not familiar with the case, brief remarks are necessary before specific issues are discussed. First, assuming this motion is heard by a new judge to understand the complicated factual and procedural history, the court may wish to review a few key pleadings, including Laura's notice of change of judge and supporting affidavit filed on July 8th, both parties' pretrial statements filed June 3rd, Laura's request for finding and facts and conclusions of law filed June 3rd, Laura's motion for judgment on the pleadings filed mid-10th, Laura's motion for extension of time to respond to respondents' motion to compel filed April 1st, and Laura's motion to dismiss with prejudice filed December 28th, 2023. The pleadings generally explain the story, and despite appearances, most, but certainly not all, of the material facts were undisputed. In short, Laura claimed she had a 90-second encounter with respondent Echard on May 20th, 2023. Laura claims intercourse occurred, while Clayton claims only oral and genital to genital grinding or rubbing took place. Did we have to put genital to genital? Like, these are statements and sentences I don't want to read. Laura claims she tested positive for pregnancy on May 31st, 2023, and on multiple other occasions, including at Banner Urgent Health Care on June 1st. Oh, it's over there probably telling Gingras. Make sure you tell them to look at the Banner Health patient portal. Make sure they look there. An unannounced surprise test given to her by Clayton on June 19th, 2023. Okay, she also stated that she brought her own test because she figured Clayton was going to want her to take one. So to act like she is just so distraught by this, she was planning on taking a test and prepared to take one. So, like, all this, surprise, not announced surprise. He made her take a pee test. On June 19th, after the parties were unable to reach any agreement, Laura filed a pro se petition to establish paternity on August 1st, 2023. Clayton filed pro se answer denying paternity on August 21st, 2023, in which he denied having sex with Laura. Clayton answered further alleged the petition was made up by Laura, i.e., Clayton claimed Laura was never actually pregnant. We've still yet to see proof. Laura claims she and Clayton agreed to submit samples for DNA testing through a company called Ravgen. After some initial delay, testing was done in late September, early October 2023. Unfortunately, the results were inconclusive, with Ravgen reporting there was little to no fetal DNA found. And that came back twice. It probably would have come back a third time and any other time that it was done. Laura claims she had a blood test done at a lab on October 16th, 2023, which showed an HCG level of 102, confirming yet again she was pregnant. The U.S. Food and Drug Administration, which is known as the FDA, HCG is a hormone produced by your placenta when you are pregnant. They produce this hormone only when you are pregnant. Sir, you were told by your own expert that you think is like the best and most experty expert of all experts that you can have a positive HCG test from things other than pregnancy. So here, where you're stating that it could only come from the placenta, that is not true. Because also explain to me why me, a woman with hysterectomy, who has no ovaries, no uterus, for a placenta to be in, also can have positive HCG in her system. Mine was way lower than Owens, but still, placenta is not the only form, that is not the only way it's produced. Last assessed July 10th, 2024. That is talking about home pregnancy tests and if you're testing for pregnancy. But that is not everything that is up for debate. And it was not said that that's the only way you can have HCG. However, at that point in her pregnancy, Laura's HCG level of 102 was extremely low. This showed the pregnancy was likely non-viable, meaning it would probably end in miscarriage. About a month later, on November 14th, 2023, Laura was seen at an OBGYN facility called MomDoc, where it was confirmed she was no longer pregnant. Yet she didn't be positive then. After learning the pregnancy had failed, Laura filed nothing further in this case, and she took no action to keep the litigation active. She just continued to lie. That's it. She continued to fabricate things. As a result, on December 4th, 2023, the court administration issued a notice pleading this matter on inactive calendar and scheduling the matter for dismissal on February 2nd, 2024. So they're going to do it after the Christmas and New Year's holiday. Shortly before the case was due to be dismissed for inactivity, Clayton retained counsel, Greg Woodnick, who appeared in this matter for the first time on December 12th, 2023. So it was supposed to go for dismissal on the 2nd of February. He found out about this on December 4th, and by December 12th, not right before the dismissal, because he didn't know what was going on. So Clayton was like, I got to figure this out because we can't let this go. So he was probably really rushing because it was placed on the dismissal calendar. Mr. Woodnick immediately filed several pleadings, including a motion to amend his answer filed on December 12th, 2023, a motion for Rule 26 sanctions filed on January 2nd, 2023. Notably, Mr. Woodnick filed these pleadings without making, God, here we go with Rule 26 again. Any attempt to meet and confer with Laura required by Family Law Rule 9C, and he moved for Rule 26 sanctions without ever providing written notice to Laura of her right to amend or withdraw her petition as required by Family Law Rule 6C to B. Woodnick has already addressed this with you, Gingras. Shortly thereafter, Laura retained counsel, Alexis Linville, who appeared on December 22nd, 2023, and filed a motion to dismiss with prejudice on December 28th, 2023. Days later, Ms. Linville withdrew from this matter with Laura's consent on January 2nd, 2024. Yeah, because Ms. Linville wanted her to fess up, and I believe she moved. Confusingly, on January 25th, 2024, Judge Mehta issued an order granting Laura's motion to dismiss, in that the ruling, the court indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will be granting the motion, the issue of sanction and attorney's fees remain. Yes. So she needed to determine things to figure out if there need to be sanctions or if Clayton deserved attorney's fees or if Laura deserved attorney's fees, whoever. So we had to get down to some nitty gritty stuff. That's probably why it was only 2 hours, because it was really only to come up with why we needed sanctions and why we needed attorney's fees. And the lies upon lies upon lies is the reason we need both for Clayton. Judge Mehta set an evidentiary hearing on those issues for June 10th, 2024, which we all watched. The undersigned was first retained to represent Laura on March 25th, 2024, after several other attorneys. After appearing in this case, undersigned counsel quickly discovered Mr. Woodnick filed the Rule 26 motions among other pleadings without first consulting Laura on her counsel, and the sanctions motion was filed without giving mandatory 10-day written warning required by providing written notice to Laura of a right to withdraw her petition as required by Rule 26C2B. After counsel discussed these problems, despite initially refusing to do so, on April 3rd, 2024, Mr. Woodnick filed a motion to withdraw his sanctions for Rule 26. Unfortunately, the request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment on the pleadings as to the issue of sanctions on May 10th, 2024. He withdrew it. No need to talk about it anymore. Like, that is not important in this case. Yes, it is a backstory of it. He filed for it. You came on. You submitted something. Woodnick withdrew it because he's like, you know what? The judge can sanction her if she wants to. I don't have to be the one like pursuing Rule 26 sanctions. The judge can sanction it all by herself. But since that was withdrawn, it is not a part of this case anymore. It's not, the Rule 26 sanctions are not what you're going after. That does not mean that there can't be other sanctions. On May 29th, 2029, this is, sir, this is the second time you've hit 2029 in one of your motions. If you could please stop doing that, that would be great. A minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motion for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn, and despite no other sanctions or fees motion pleadings or fees motions pending, the case proceeded to trial on June 10th, 2024. There was still attorney's fees to be decided. Just because he did the sanctions, got rid of the 26 sanctions, doesn't mean there wasn't anything else to still go ahead with. On June 17th, 2024, filed June 18th, 2024, Judge Mehta issued an order finding in favor of Clayton as to substantially all issues in the case and awarding attorney's fees in an amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in this case, as well as two other matters. She may have committed perjury in the case or elsewhere. The order is not entirely clear. Based on those findings, Judge Mehta referred this matter to the Maricopa County Attorney's Office. Yeah, as she should, because anybody that is doctoring evidence and submitting it to the court and lying and lying and lying when she shouldn't be lying. Like, you should have no reason to lie because you want people to believe you, one, when they don't. So why are you gonna continue to do things to make people not believe you even more? And if you have something to prove it, why don't you submit it? It's because you don't have anything. Structural error discussion. As explained in detail in the notice of change of judge filed in this matter on July 8th, 2024, clear and convincing evidence shows Judge Mena violated Laura's due process rights in the Code of Judicial Conduct by conducting a secret, undisclosed investigation into the matters or facts of this matter. You do not have proof of this. Secret investigation. Yes, she's just got all her cohorts. She's just secretly going undercover and trying to find things on Laura. That is not what happened, and I think it is. It's just not what happened, and you're trying to spin it into something that it wasn't. Worse, Judge Mata not only reviewed social media posts about this case. How do you know she reviewed social media posts? She literally made at least one key factual finding or more based on those posts and not on the evidence admitted at trial. You don't know that she got any information off of social media. Where is your proof? The consequences of this are both simple and clear. Laura is entitled to an order vacating judgment in its entirety, and she is entitled to a new trial for a different judge pursuant to family laws Rule 6.1 and 84.1. Rule 83.A provides in relevant part grounds for altering or amending a judgment. The court may on its own or motion alter or amend all or some of its rulings on any of the following grounds material affecting a party's rights. A, the court did not properly consider or weigh all of the admitted evidence. She did do that. B, any irregularity in the proceeding or abuse of discretion depriving the party of a fair trial. I don't know if she did that. C, misconduct of the other party. Misconduct on your party. D, accident or surprise that could not reasonably have been prevented. That's not something that happened. Newly discovered material evidence that could not have been discovered and produced at trial with reasonable diligence. Well, like there should be some newly discovered evidence that wasn't discovered. It could have been discovered with the help of your client if she would have, signed a HIPAA release for Los Angeles. F, error in admission or rejection of evidence or other errors of law at trial during the action. Didn't have any of that. G, mistakenly overlooked or misspelled uncontested facts, including mathematical errors which were necessary to the ruling, or which she got a date wrong, but I don't think he's talking about that. Or H, the decision, findings of facts, or judgment is not supported by the evidence or it's contrary to law. I don't believe we have that either. Gingras thinks so. I'm guessing all the underlying ones are the ones that he thinks are happening in this case. When grounds exist to do so, Rule 83B provides the court may vacate the judgment if one has been entered, take additional testimony, amend finding of fact and conclusions of law, or make new ones, and direct the entry of a new judgment. I think if you're asking a new female judge to look at this, she's still going to look at Owens and think she's crazy because she's a woman. Now, a man might fall for it. I would hope not. I would hope with everything that they just wouldn't be so stupid. But Duty, Commissioner Duty has fallen for her tricks twice now. Here, multiple grounds exist for relief under Rule 83. Also, if anybody is a father that has seen their wife or baby mama or whoever go through having a child, they will also know that this is not how any of it works. So maybe some men be stupid. So I don't want to be like looking prejudiced against gender, but the reason I bring up that another female judge is because the presiding judge over Mara is another female judge. So I don't know that it's going to help. I don't think anybody looked at this other than the two of them um, believing in this jargon. However, because the improper conduct of trial judge deprived Laura of her most basic right to fundamental fairness, it is not necessary to consider any issues but one, the independent investigation into the facts undertaken by the trial judge Julie Otto. The single event standing alone invalidates the judgment in its entirety, without regard to other lesser but still significant errors of both fact and law committed by Judge Mata. As such, the issue will be discussed first. Assuming the court agrees and orders a new trial, it is unnecessary to consider or resolve any other issues at this time. Those other issues will still be briefly addressed solely to preserve the appellate record. And this is what I think he's doing. I think all of this, because I don't think any of this is going to go the way he wants it to go or thinks it should go. Um, I think all of this is to preserve for the appeal that he wants to do. Because he's always like, well, win it in the appeal, win it in the appeal. He never has thought he's going to win this case. And as we saw, I think it's because he knew Owens is lying. As such, the issue occurred. A. Judge Mata's undisclosed independent investigation into the facts with structural error required automatic reversal of the judgment and a new trial before a new judge. Before addressing other issues pursuant to family law rules 83A, B, and 85B6, Laura moves for an order that the judgment be vacated in its entirety and new trial ordered before a different judge on the basis of misconduct committed by the trial judge, specifically as explained below and in the notice of change of judge for cause filed concurrently herewith, which is incorporated by reference herein. There is clear and convincing evidence proving Judge Mata violated inter alia Rule 2.9c of the Arizona Code of Judicial Conduct, which provides, except as otherwise provided by law, a judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may properly be judicially noticed, emphasis added. Laura has separately reported this misconduct to the Judicial Conduct Commission. Of course she has, because she is a Karen. And her mom is a Karen. So they need to run and go talk to the managers. They got to go report things to the bar and the judges commission and all that. Like report everybody because they reported me. Here, irrefutable evidence demonstrates Judge Mata violated Rule 2.9c by conducting her own internet research into the facts of the case. She did so by reviewing information posted online regarding this case, and even worse, she adopted one or more statements of fact into the judgment, which were not based on evidence at trial, but rather were based solely on statements published on the internet by Clayton's supporters. Why did she have to get it off of social media? She did not have to get it off of social media. And you're saying one or more. Is there more, or is there just the one? Which you still don't have any proof of. A. Legal standard. Few legal rules, if any, are clearer than this. Both federal and state constitutions guarantee that no person shall be deprived of life, liberty, or property without due process of law. Meacham v. Gordon, Arizona, 1988. And of course, the touchstone of due process under both the Arizona and federal constitutions is fundamental fairness. Mitchell v. Palmer, Arizona 2024, emphasis added, quoting State Melendez, Arizona 1992. Ergo, a party's right to fundamental fair trial is critically important because it preserves both the appearance and reality of fairness, generating the feeling so important to a popular government that justice has been done. Palmer Supra, cleaned up, quoting Marshall v. Jericho Incorporated in 1980. Fundamental fairness in context of due process has many different facets, but the key one is this: all litigants in all courts are entitled to have their eases heard and decided by a judge who is fair, neutral, unbiased, and impartial. I think you had that. I think people were more than fair with y'all. The fact that she's not in jail right now shown the fairness. Although the right to a trial before an impartial judge is not specifically enumerated in the Constitution, this principle has long been recognized by the United States Supreme Court, State v. Dorsey, Minnesota 2005, noting to maintain public trust and confidence in the judiciary, judges should avoid the appearance of impropriety and should not act to ensure that parties have no reason to think their case is not being judged fairly. How is it not being faced fairly? Your client is a liar, a proven admitted liar, and the judge agrees that she is a liar. Citing Rose v. Clark, 1986. Some other things. Impartiality is very foundational of the American judicial system. Seen crime victims R.S. v. Thompson, Arizona 2021, explaining the denial of due process is denying fundamental fairness, shocking to the universal sense of justice. God. Although Arizona case law on this exact issue is sparse because instances of judicial misconduct in this state are thankfully rare. The United States Supreme Court has repeatedly agreed due process clause requires trial judges to be fair and unbiased, and requirement is not illusory or illusory. What a big word. The deprivation, the deprivation of a fair and unbiased judge is a structural error requiring automatic reversal of the judgment. United States, 1999, discussing differences between harmless error and structural errors, and explaining we have found an error to be structural and thus subject to an automatic reversal only in a very limited class of cases, such as defects as the complete deprivation of counsel or trial before a biased judge. Emphasis added, cleaned up. Biased trial judge constitutes a structural error, but she's not biased. And if she did look at something which you have not proven, you're speculating, then it seems harmless. It didn't cause harm. Like, and you could take out that whole thing if they were like, okay, we can just do it, but on this Planned Parenthood thing, on the hours, you can't base your judgment on that. She still comes out as a liar. As it must, the Arizona Supreme Court embraces the same standard. In cases involving trial error, we consider whether the error so assessed was harmless beyond a reasonable doubt. If so, we uphold the verdict In a limited number of cases, however, structural error occurs. In such instances, we automatically reverse the guilty verdict entered. Unlike trial errors, structural errors deprive defendants of basic protections without which a trial cannot reliably serve its function as a vehicle for determination of guilt or innocence. Well, this is not a criminal trial. There is no guilt or innocence. It's liable or not liable, and no punishment may be regarded as fundamentally fair. And then he cites some other stuff, presumably due to the high risk standards imposed. Arizona jurists comparable instances of a judge conducting an undisclosed investigation into the facts of the case and adopting findings based on that investigation, as occurred here, are essentially non-existent. However, courts in other states applying the same legal standards are in unanimous agreement. It is structural error, requiring automatic reversal when a trial judge conducts an independent investigation into the facts of the case. This is so because bedrock due process argument of fairness requires that a conclusion reached by the trier of fact be based upon the facts and the evidence, and prohibits the trier of fact from reaching conclusions based on evidence sought or obtained beyond that adduced in court. Okay. Get what he's saying. Thus, if a judge, especially in a bench trial, undertakes a personal investigation into the facts of dispute or makes findings based on his or her own independent research or knowledge, rather than based on the evidence admitted at trial, this conduct is per se violation of the due process clause, which constitutes structural, not harmless error. They can't use their own knowledge. They can't use common sense. She has been in family law before. But it'll be interesting to see what comes out of this, for sure. He states, first, the judge sitting as the fact indicated by her comments during Worthy's testimony that she believed, based on facts, not evidence, and Worthy's statements about the date of Page's death were likely false. These comments disregarded the judge's duty as the finder of fact to make factual determinations, solely on the basis of evidence in the record. Second, the judge independently investigated a fact not introduced into evidence, violating her obligation as the finder of fact to refrain from seeking or obtaining evidence outside the presented by the parties during the trial. Rice Bros v. Filigico, the Sixth Circuit Court of Appeals stated, unquestionably, it would be impermissible for a trial judge to deliberately set about gathering facts outside the record of a bench trial over which he was to preside. Oh, I was talking about a death. Dorsey. Cleaned up, reversing defendant's conviction and ordering new trial upon finding trial judge violated defendant's due process rights by conducting an investigation into the facts of the case. Quotings. Ordering new trial where judges in a bench trial considered facts not admitted into evidence and reaching his conclusion. The law on this point could not be clearer. Judges are absolutely forbidden, both as a matter of due process and judicial ethics, to conduct independent investigations into the facts of a case, and they are absolutely forbidden from making factual determinations based on the results of those investigations. Findings of fact may only be based on the evidence admitted at trial or matters which may properly be judicially noticed. A judge shall not investigate facts independently and shall only consider the evidence presented and any facts that properly be judicially noticed. Okay, we just keep repeating the same thing over and over. And comment 6, the prohibition against the judge independently investigating the facts in a matter extends to information available in all mediums, including electronic. See also American Bar Association's formal opinion 478, independent factual research by judge via the internet, December 8th, 2017. Explaining a judge may not use the internet search to determine hours of operation nor business hours properly subject to judicial notice. This internet search violates rules 2.9c or the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail. But we found something that was more recent than 2017 that was in the Supreme Court. When a judge ignores the most basic principles and conducts an independent investigation, the results of structural error require automatic reversal, regardless of whether the expert evidence found by the judge is true, false, or completely accurate. We conclude that Dorsey was deprived of the basic protection of an impartial judge and finder of fact when the judge independently investigated a factual assertion made by a key defense witness and revealed the results of our investigation to counsel. The deprivation constituted structural error, which precludes harmless error analysis and requires that we reverse without regard to the evidence in this particular case. He's already cited this other thing. Reversing in a family law case, trial court's order vacating stalking order where a judge investigated facts independently, an improper ex parte investigation by a district court prejudicial when it bases its rulings even in part on an investigation in fact that is inferred from that investigation. Reversing conviction and ordering a new trial before a judge where the district court made an important finding of fact that is not based on any evidence introduced at trial, but rather is based on facts always known or believed by the district court judge. The district court's error is a structural error that requires automatic reversal of the conviction and a new trial. Blah, 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 blah. B. Structural error occurred here. On page 10 of the judgment, Julie Mata made the following finding of fact, which was reportedly based on testimony from Clayton's medical expert, Dr. Samantha Deans. Dr. Deans, testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified she sought care July 2nd, 2023, and this is added. The underlying text quoted above proves conclusively that Judge Mata committed structural error by performing a secret, undisclosed ex parte investigation into the facts of this case. This necessarily included the judge reviewing information posted on the internet by Clayton's followers, which she then adopted as a finding of fact that conclusion is supported by two things. You don't know that she got it from social media. Like, we don't even know if she did this. There are pages in the medical report that we haven't seen. Gingras has seen them. And I would hope if Dr. Deans did state that in the parts that we haven't seen of Dr. Deans' medical expert opinion, that he would not be doing this, because if it was in her expert opinion, then he shouldn't be able to bring this up because that was evidence that she was going to be looking at. Just because it wasn't said at the hearing, she said she was going to review all the material that had been submitted in this case when making her judgment. So I would hope that it's not in that. The underlying text proves okay. First attached to the notice of change of judge is true and correct copy of the transcript for the trial held in the matter of June 10th, 2024. As reflected in the transcript, Dr. Dean never testified Planned Parenthood is not open on Sundays. Nothing remotely approaching this was ever stated by Dr. Deans or any other trial witness. Indeed, the word Sunday appears nowhere in the trial transcript. This leads to the second point. If conclusions that Planned Parenthood is not open on Sundays did not come from the testimony of Dr. Deans or any other trial witness, it begs to question, where did it come from? The finding was based on statements published on social media by Clayton's followers, or Googling Planned Parenthood hours. Like, you don't have to look at social media to find that out. Like, there are other ways to find out Planned Parenthood's hours. But, you know, this is how we know Judge Mata conducted an improper investigation into the facts of the case, because her finding regarding Planned Parenthood's hours of operation was not based on any evidence at trial. It was copied verbatim from social media comments, including a comment posted the day of trial on the personal website of undersigned counsel. And he links his thing. And then he's got the picture screenshot of the comment about that on his blog post. This evidence is standing alone sufficient to prove structural error. As a result, Laura is entitled to an order vacating the judgment in its entirety and ordering a new trial for a different judge pursuant to Family Law Rules 6.1 and 83B. 2. Other errors warrant correction. Reversal. Assuming structural error occurred, nothing else matters. Automatic reversal is the only permissible option. However, to ensure a complete record, Laura also raised various other arguments regarding factual and legal errors contained in the judgment and the pretrial proceedings. A legal error. To prevent this brief from exceeding 100 pages or more, a full discussion of all legal errors committed by trial judge is impossible. Instead, each point is only raised in the shortest format possible to ensure non-waiver for appeal. Once again, he's stating all of this is for appeal. I think that's all this is. He wants grounds to appeal on, so he's got to make the record. Sanctions were unavailable as a matter of law. No. On May 10, 2024, Laura filed a motion for judgment on the pleadings and renewed motion to dismiss. The motion explained it was undisputed. Clayton's counsel ignored the safe harbor requirements of family law, Rule 26C to A and 26C to B. I.e. Mr. Woodnick never made an attempt to meet and confer with Laura before seeking sanctions, and Laura was never provided with the 10-day written notice regarding her safe harbor rights. Because of that undisputed error, the motion explained that the trial judge was not permitted to fix Mr. Woodnick's mistake by granting sanctions under other authority, i.e. sua sponte. She is allowed to give sanctions on her own if she finds that the behavior is gross. I think any judge can give sanctions for that. They can sanction an attorney for their misbehavior. So I don't think she waives anything as a judge that Owens automatically doesn't get sanctions because Nick took away the Rule 26 sanctions. Because also Gingras states in all that, now this doesn't prohibit other sanctions, but it does prohibit this. He even states it in his motion about the Rule 26 BS that he's written about 20,000 times. I'm so tired of Rule 26. We need to 86 Rule 26. If you know what 86 is, you know. As is true of substantially every other legal issue, the trial judge simply ignored this argument and awarded sanctions without any legal grounds to do so. This was clear error of a matter of law. She didn't have any grounds based on her conduct and submitting horrible evidence, like perjury, all that. Like, she didn't have grounds to do it. I think she had plenty of grounds to do so. The bench trial violated Laura's right to a jury trial under Arizona's Constitution. Just days ago, the United States Supreme Court issued a decision explaining that litigants cannot be denied the constitutional right to a jury trial simply because the rules of a forum do not permit a jury trial. In the case SEC v. Jarsky 2024, Lexus 2847, June 27, 2024. Okay. Well, this happened after Owens' trial. So I don't know if it's going to make a difference, but sure, put it on the record. The Supreme Court explained the right to a jury trial does not depend on the type of forum or specific label of the claim at issue. What matters is whether the remedy sought is legal in nature. If so, the constitutional right to a jury trial attaches no matter what forum the case may be in or how the claims are framed. You do not, I repeat, do not want this to go to a jury because the jury would be awarding all sorts of to Clayton. You don't want this to go to a jury because the people that are peers in the area are not going to see this the way that y'all are trying to get us to see it. It's just not happening. Your best bet was to try to do it with law because you don't have facts on your side. And you couldn't do it with the law. You do not want a jury that does not understand all the legal stuff, all the people that you consider plebs that aren't attorney and they're uneducated and they're stupid and all this other stuff that you like to call people. You want them deciding Owens' fate? That might be the dumbest thing I've heard from you so far. The Seventh Amendment extends to a particular statutory claim if the claim is legal in nature. What determines whether a monetary penalty is legal is if it is designated to punish or deter a wrongdoer, or on the other hand, solely to restore the status quo. As we have previously explained, a civil sanction that cannot fairly be said solely to serve a remedial purpose, but rather can only be explained as to serve either retributive or deterrent purposes, its punishment and therefore requires a jury trial. Okay, so she's saying you cannot he's saying you cannot sanction on behavior. You can't do that to punish people because only juries can punish people, not judges. Judges can't punish people with money, apparently, is what he's stating. It seems like. I could be wrong. And he's quoting authorities. To be clear, Jarsky only addresses the federal jury trial right under the Seventh Amendment and specific provision of the Bill of Rights does not apply in state courts. See Edgerton, 2014, explaining the Seventh Amendment right to jury trial does not apply to the states. The point is irrelevant, however, because both Article 2, Section 23, and Article 6, Section 17 of the Arizona Constitution provide in pertinent part the right to a jury trial shall remain inviolate, and courts interpret Arizona constitutional provisions protecting the right to a jury trial consist with the Seventh Amendment. To be fair, in Fisher, the Court of Appeals rejected the appellate's argument, providing for an award of attorney's fees in certain appeals from compulsory arbitration, violated her right to a jury trial under Arizona's constitution, but the finding was based on two materially different facts. The possibility of a fee award here does not act as an unreasonable or significant burden impairing the right to a jury trial. Rule 77 and ARS 12-133I both provide safeguards to ensure that the right of a jury trial jury decide ultimate issues is not sufficient burden or impaired. The Superior Court is limited to awarding reasonable attorney's fees and expert fees, and may decline to award such fees if it would create significant economic hardship on the appellant. Here, both of these safeguards were entirely absent. First, as the initial matter, unlike Fisher, here the ultimate issues were not decided by a jury, they were decided solely by the court. The fact standing alone explains why this case is completely different from Fisher. Then why are you quoting it? Second, Clayton has requested an award of more than $150,000 in fees, and there is no provision for the court to decline to award those fees based on economic hardship. Third, Clayton asked the court to find, and it actually did find, that Laura engaged in fraud and other conduct that would be tortious and actionable in a civil proceeding, assuming it was true. It's not. That's your opinion, and a judge has said otherwise. Along with everybody in America other than Owens' family and you. In effect, unlike the outcome in Fisher, what occurred in this case is not that a single judge was permitted to decide all ultimate issues in the case and then awarded an unlimited amount of fees to punish Laura as a result. She didn't say an unlimited amount of fees. That was not stated. um The outcome clearly and directly violated Laura's right to a jury trial under Arizona Constitution. She never stated she wanted a jury trial. I don't know if anybody ever asked her, but she never stated it. 3, the court lacks subject matter jurisdiction over tort claims such as defamation, fraud, and extortion. In her very first substantial filing after retaining counsel on December 28, 2023, Laura moved to dismiss this matter with prejudice. In that motion, Laura asserted the court had subject matter jurisdiction pursuant to ARS 25801 to establish maternity or paternity. Because Laura acknowledged she was no longer pregnant, the motion asserted the case was moot, and the court no longer had subject matter jurisdiction over any issues other than attorney's fees, while noting Clayton was not entitled to fees because he failed to comply with any of the procedural requirements of Rule 26. God, this is the most BS, blah, blah, blah I've read. Like, this is god awful. Whoever has to read this and respond to this, I'm sorry. And I'm sorry I'm putting you through this because this is garbage. Along the same lines, notwithstanding the fact the court did have jurisdiction to decide issues of paternity, it is equally clear this court lacks subject matter jurisdiction. Oh my God. Sob sit here. Issues of paternity is equally clear the court lacks jurisdiction over all the ultimate claims and issues decided at trial. That is particularly true given that the paternity was not a disputed issue that was ever actually necessarily litigated. The final judgment does not purport to make a finding of non-paternity, but the relief is not provided for in any subpart of Title 25, Chapter 6. I believe there was a finding of non-paternity. In short, you have never been short about anything except for nothing, never mind. In short, while presenting his primary claims as a request for sanctions, the substance of Clayton's argument at trial were and always had been that Laura lied about being pregnant. That Laura published false statements about Clayton in media, and that Laura attempted to use fabricated pregnancy claims as a means to extort Clayton into dating her. All of these tort and claims and theories would support cause of action if they had any valid factual basis, which they did not. But Clayton could have litigated those tort claims in the limited jurisdiction of family court, and he could not have invoked the family's court jurisdiction as to those claims under Title 26, Chapter 6. Traditionally, civil tort theories such as defamation, fraud, and civil extortion surely could be pursued in a normal civil department of this court, in which both parties would have mandatory rights to have the ultimate issues decided by a jury, and where the available remedies would be vastly different. For instance, if Clayton had sued Laura for defamation and won, he would not be entitled to the award of attorney's fees, since legal fees are unavailable as to a matter of law in defamation cases. Are they? Might be an wasn't couldn't Depp end up getting attorney fees in his defamation case of Amber? Attorney fees be awarded Depp? That's interesting. I mean, he's citing something that states that. Um, however, there are exceptions to the rule. Yeah, the judge can order attorney's fees in defamation cases. There are things that can happen. A lot of times, each person just pays it, but it can be ordered. Probably in crazy cases where people have lied and done things with malice, actual malice. Indeed, not only could such tort claims be properly brought, and only in the Norfolk Civil Division, as explained in Laura's request for judicial notice filed on April 12, 2024, Clayton's counsel, Greg Woodnick, previously tried exactly that approach by bringing civil tort claims against Laura for fraud and intentional infliction of emotional distress in Owens v. Gillespie. As shown in the request for judicial notice, Mr. Woodnick lost the case. One of them won. Both of them lost in that. It wasn't that Woodnick just lost. Neither one of them won because there was nothing proven there. With the court granting summary judgment as to counterclaims, this helps explain Woodnick's decision to bring essentially the identical tort claims in a different court, knowing this court lacking subject matter jurisdiction over these nature. Well, the fact that this was a paternity case and she lied in this paternity case, I think it makes it that. She still could not prove she still couldn't prove she was pregnant, and she could not prove that she was pregnant with Clayton's babies, which is what this case was all about to begin with. She was proven to lie in this case about everything. The court applied the wrong legal standard. As a general rule, parties who come to court seeking judicial assistance are not subject to this likely evidentiary standard. Parties who bring claims made before discovery has begun are never required to exhaust every possible avenue to confirm, verify, and double or triple check the veracity of their allegations before filing the suit. She knew she was lying when she filed it. It wasn't like she didn't know. That's the problem in your case. She did know. It wasn't like, oh, she discovered she was lying. No, she knew from the very beginning. On the contrary, the Supreme Court, like essentially every court in the United States, merely requires that litigants conduct some reasonable investigation into the facts and that they have an objective bias to believe their claims may be colorable. A claim is colorable when it has sought some legal and factual support considered in the light of a reasonable belief of the individual making the claim. The question is whether a reasonable attorney could have concluded the facts supporting the claim might be established, not whether such facts actually have been established. If that was the only thing that had happened in this case, maybe. But the fact that she continued to lie and lie and lie with whole discovery, that to me makes this crap moot, in your words. Boone v. Superior Court in 1985. Emphasis in original. To restate the correct legal standard, the question is not whether an allegation made in pleading has actually been established before the case is brought, which is incorrect legal rule applied here. Rather, the question is whether the party asserting the claim has some plausible basis to believe their factual allegations might be established. Why do they need to be established if you know if she was in fact pregnant like she said she was? I think that's just different. Again, the Arizona Supreme Court has repeatedly and consistently found sanctions are not justified simply because a litigant asserted a claim that was ultimately not successful. That is not what happened here. You are living in a delusional world. She lied. You know what? Yep, 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 yep.
Not pregnant at that time, and she lied.
She lied. Again, the Arizona court consistently found section. Even under the more stringent provisions of the recent revision to Rule 11A, counsel is required only to make an investigation which reasonable under the circumstances that exist at the time of filing the pleading. The new rule requires no more than a good faith belief formed on the basis of that reasonable investigation that a colorable claim exists. The rule is not to be used to require counsel to offer proof of the pleading before discovery and before trial. But she has been claiming this entire time that she was pregnant when she was not. And I don't think she did a reasonable investigation into her pregnancy because she had those fetal sacs, so she claims, in July before she filed this. She did not make a reasonable investigation into whether that was a miscarriage. To me, she didn't make a reasonable investigation. A reasonable person would not do the actions that she did. Here, in the post-trial judgment, the court purported to find Laura filed this action without substantial justification because, in the trial judge's view, Laura failed to act reasonably in seeking prenatal care and failed to take reasonable steps to verify her pregnancy. Specifically, the petitioner acted unreasonable when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with belief she passed tissue in July. The court's fine underlying petitioner premature at best. That's kind of what I said. Those findings and resulting awards of sanctions were based on a clear, erroneous application of the wrong legal standard. First, nothing in Arizona law requires a woman to have an ultrasound, sonogram, or physical examination, or any other procedure before she may bring an establishment petition under ARS 2586A. That provision requires nothing more than a verified petition that alleges that a woman is pregnant with a child conceived out of wedlock and that the respondent is the father of the child or children. Well, maybe it's time for a change so that women can't just get pregnant and go rack up some attorney's fees and try to get money and a baby by and trying to break them. Second, the correct legal standard is whether or not Laura acted unreasonable when she initiated litigation without basis of merit. This is purely erroneous legal rule. Instead, the question is whether at the time she filed this action on August 1st, 2023, did Laura have some basis to think she might be pregnant and that Clayton might be the father? My answer is no, if they only had she didn't have a basis to think it was Clayton's. That, to me, rolls it out automatically. But just because she took a positive HCG test, she should have gone to a doctor. The question is whether a reasonable attorney could have concluded the facts supported the claim might be established, not whether such facts actually had been established. Emphasis is original. Yeah, but she still didn't drop the case on that merit. She didn't want to drop the case because it wasn't established or it couldn't be established. She dropped it because she wanted to quit being pregnant because people were pointing out too many of her lies. Which events which occurred after August 1st, such as the low 102 HCG test result, some 2.5 months later in mid-October 2023 are completely irrelevant to that issue. Again, the relevant question is whether Laura believes she might be pregnant on August 1st, 2023, regardless of whether she miscarried later and regardless of whether she was, in fact, never pregnant at all. I don't think people who believe hysterically that they're pregnant should even be able to do this. There's got to be some more play. Probably because when they wrote this stuff, they didn't think people would actually come to court doing this nonsense. But we need to update it because people are more sick and demented than we thought. It is undisputed fact that before this action was filed, Laura tested positive for pregnancy on multiple occasions, including a surprise test taken in his residence. He admitted in writing that sexual contact with Laura might have resulted in pregnancy. He said, in his own words, it was also undisputed Laura asked Clayton to agree privately to a DNA test, which would have confirmed or not both existence of the pregnancy and paternity of the father. Yeah. And 2 tests came back, little to no fetal DNA. And one of the tests she took the HCG blood test the same day she took the Rabgen test, or that she got the results. One of the two, on her way home from Rabgen, she decided to go by there. So you know how we know that that test was accurate? It is because she had this low HCG level. And so if she had that the day that she was also showing little to no fetal DNA, those were taken on the same day. The ones that were before that also proved little to no fetal DNA before this little low HCG level. To me, that connects the two. It proves there's little to no fetal DNA. You just have some HCG in there. Although Laura maintains that she was, in fact, pregnant, applying the correct legal standard, here it actually would not have mattered if Laura was pregnant at all. Indeed, one of Clayton's arguments, albeit one which lacked any factual basis, is that Laura may have taken epilepsy medication that produced a false positive. But she admits she takes epilepsy medication. So how do we know that that's not what was causing it? Like, it could be. There is another reason that this could be positive. And I don't know if she switched medications in the middle of all this either, which means that she is not testing positive anymore. That could be the difference in the test. Although Clayton's medical expert offered no testimony to support this, and although Laura's medical expert directly rejected this theory, it is theoretically possible that Clayton was right. Perhaps Laura was never actually pregnant, but unbeknownst to her, one or more of her medications caused her to receive multiple false pregnancy tests. I'm glad you're agreeing with that. I know you think it doesn't matter, but I'm glad you're saying it, because you know that's true. In that situation, there would be no basis to sanction Laura for unknowingly filing the action based on a freak medical scenario of which she was completely unaware. If they did not have sex, and she knows that they didn't, and she is taking this medicine, she had to know that she was not pregnant. Like, there was no reason to think that she was if they actually didn't have sex. A freak medical scenario. It would be a freak medical scenario. The Virgin Mary, which we know she is not. Indeed, the undisputed evidence at trial showed Laura attempted to investigate this possibility of a false pregnancy test by discussing the issue with her doctor before the case is filed. See judgment at 5 through 6, noting respondent suggested that the positive test was the result of a petitioner's epilepsy medication. Petitioner emailed Dr. Zyman, MD, from Barrow Concussion Brain Injury Center. The subject of the email is pregnancy and seizure medication. This is her reporting to her seizure doctor person that she's pregnant. It's not proof. Here, the undisputed facts are that Clayton made a written admission that he saw at least one positive pregnancy test. Laura took in front of him on June 19, 2023, lending him to question whether Laura may have taken medicine that was false positive. Before the matter was filed, it is undisputed Laura discussed that exact issue with the doctor in an email sent on June 28, 2023. Even if the medical advice Laura received from her doctor was wrong, and there is no basis to support such conclusion, even if Clayton's theory was right, i.e., that there's epilepsy medication caused a false positive result, and even if Laura was never actually pregnant at all, there is simply no evidence to show that she knew all these things before the action was filed. Yes, she did. Thus, the trial court had applied the correct legal standard, and it could not have properly found Laura lacked good faith basis to think she might be pregnant when this action was filed, even if that belief was incorrect. If she believes Clayton and his story that they didn't have sex, then she also can conclude that Owens knew she was not pregnant when she filed this, therefore she can be sanctioned. The court misapplied ARS 25324. This is ongoing. The final judgment awards ARS 25324 based on the finding of unreasonable litigation conduct on Laura's part. This is plain error because ARS 25324 does not apply to paternity proceedings. It only applies to the cost and expense of maintaining or defending any proceeding under this Chapter 3 or Chapter 4, Article 1 of this title. The correct statute for a fee award in the paternity action would have been ARS 25809G, which contains essentially the same standard. The court may order a party to pay a reasonable amount to the other party for the cost and expenses of maintaining or defending any proceeding under this article. Well, if she kept it going with lie after lie and not turning over discovery that could have possibly ended all of this, I think that all of this is reasonable. Because it kept having to defend it, and then you kept putting stuff out here, which made it worse. If you wouldn't have done everything that you did in this case, her bill would be cheaper. Sure. But here the court erred in a matter of law because ARS 25809 only permits an award to a party engaged in unreasonable litigation conduct. Such conduct necessarily caused the other party to incur unnecessary fees and costs. I just explained that y'all's unnecessary mumbo jumbo caused all this. For the purposes of this subsection, costs and expenses, including attorney's fees, deposition cost, appellate cost, and other reasonable expenses, the court determines were necessary. Here, essentially every penny of the legal fees requested by Clayton involved work done after Laura moved to dismiss this matter with prejudice on December 28, 2023. By moving to dismiss with prejudice, Laura offered to give Clayton all the relief he was entitled to. No, he didn't, because he still would not have something that said, you are a liar, which is what he wants. Thereby obviating any need for further litigation, as was explained in Laura's motion for judgment on the pleadings filed 10, 2024. Substantial legal authority supports the conclusion that the sanctions and fees are not available as a matter of law once a party offers to withdraw their claim with prejudice. Defendant's basis for even threatening to seek Rule 11 sanctions based on the alleged frivolous pleading, let alone formally moving for such sanctions, evaporated on March 2nd, 2023, when counsel offered to stipulate to dismissal of the entire case with prejudice. Western v. Mueller, the underlying purpose of the safe harbor Still talking about safe harbor. Ability to move sanctions is still 26 sanctions. Here, once Laura removed to dismiss with prejudice, there was absolutely no need for further litigation as to any paternity issues with family court jurisdiction. Of course, Clayton refused to accept this because he did not care about any paternity issues. Instead, he wanted to use this action to continue litigating tort claims that were effectively identical to those Mr. Woodnick brought and lost on behalf of Mr. Gillespie. Owens also brought and lost on these. But Clayton's decision to unlawfully misuse a family court proceeding to litigate pseudo-evil tort claim does not mean that such work was necessary to resolve the attorney claims within the meaning of ARS 2589G. Who was going to give him the thing that said, you are not the father? Owens is a liar and she needs to go to jail. Like, who was going to give that to him? If he would have dropped this case, she would have kept on doing this. Factual errors. Multiple subparts of 3A1 permits mistakes in the judgment to be corrected for various reasons, such as where court did not properly consider admitted evidence. Rule 83A1A, mistaken applied uncontested facts. 83A1G, or where finding of fact is not supported by evidence. Rule 83A H. Here, the judgment contains multiple factual errors which implicate one or more parts of 83 accordingly, those errors should be corrected as follows. We almost done. Page 2 of the judgment contains the following. Laura Owens, petitioner, filed pro petitioner. Okay, so he's correcting the May 20th, 2023, filed on August 1st, 2023. Page 2, the judgment on October 6th, 2023, petitioner filed an ex parte protection. After hearing the order of protection was confirmed the same day, the RABGen results indicated ruling fatal delay. As to the last sentence of this finding, the RABGen results were received on the same day, October 6th. The finding is unsupported by any admitted evidence. If she knows when the RABGen results came in, which didn't just, no, you didn't say that. You said mid-October. Okay. Page 2 of the judgment contains the following. October 25th, 2023, the parties appeared for commissioner duty to determine validity. The order testified the validity of the sonogram, sent to respond to the media dropback. She later testified she believed she was having fraternal twins, 1 boy and 1 girl. As to the findings, she testified to the validity of the sonogram. She sent responded the media and Dropbox on Reddit. This finding is contrary to the evidence and is not supported by any admitted trial evidence. As to this last sentence of the finding, i.e., that Laura testified before Judge Duty that she believed she was having fraternal twins, 1 boy and 1 girl, the finding is factually unsupported by any evidence because Laura never offered such testimony. Okay, she didn't testify, but she stated she's having twins. This is the boy's profile. And it is somewhere else in documents, in court documents, before you came on, that she was having a boy and a girl. Part 3, the judgment contains the following findings. December 6, 2023, a second rapid test confirmed little to no fetal DNA. As to the date of the rapid test, December 6, 2023, this finding is factually unsupported by any admitted evidence. Did she get something that said this was the test result on this? I believe it's in there. Part 3 of the judgment contains the following. December 28, 2023, petitioner filed a motion to dismiss petition for established paternity legal decision making parenting by child support prejudice in conjunction with the notice requiring strict compliance with Arizona rules of evidence, thereby invoking ARFLP Rule 2A. Petitioner cited the basis for dismissal that she is now not pregnant with respondent's child. The motion was denied as an issue of attorney's fees, costs, and sanctions were made. As to the last sentence of the finding, i.e., motion to dismiss filed by Laura on December 28th, was denied. That finding is not supported by any admitted evidence and is overlooked or misapplies uncontested facts. The docket in this matter reflects on January 25th, 2024, the court issued an order granting Laura's December 28th, motion to dismiss the following language. Petitioner advised she is no longer pregnant. And filed a motion while the court will grant the motion, the issue of sanctions and attorney fees will remain. 6, page 4, the judgment contains the following. At trial, petitioner testified that the parties had sexual intercourse and that it was art. This finding misstates the evidence. Laura asserted both at trial and before that Clayton briefly inserted his pee into her V without her consent, and this conduct may fit the technical definition of art, but that she did not intend to accuse him of art, and that she did not personally consider his conduct to be art or any kind of crime. Are you effing kidding? Did she not put that in her affidavit, in her pretrial statements affidavit, when she started claiming that he arbitred? Seriously? She said no such thing. Does he not remember that the judge said that she was going to be looking at things that were submitted in this case and looking at all the material before she made her decision? So yes, this stuff was discussed. Just because it wasn't said at trial does not mean that it didn't happen. Page 4, the judgment contains the following finding. Petitioner testified she has been pregnant 4 times. Each time the alleged father believed fabricated the pregnancy and doctored medical records. As so, the second sentence of this finding, the finding was not supported by any admitted evidence. In addition, the specific question regarding the beliefs of other third parties was subject of an objection as to lack of foundation, which was sustained. Yeah, but she has proof in other things this happened. She has that in filings. She also admitted things in depositions. So she has admitted that all of them accused her of lying and fabricating stuff. Page 5, the judgment contains the following fact. It's something to consider. Email maintains the lack of sexual intercourse would prelude him from being the father of the fetuses. This finding is not supported by and directly contrary to the admitted evidence in the something to consider email. Respondent specifically stated exactly the opposite of the court's finding, i.e., the lack of sexual intercourse would not preclude him from being the father because respondent admitted there was sufficient other sexual contact that pregnancy was possible, even though he believed the likelihood very low. Well, just because Clayton may be a dodo bird doesn't mean that Judge Muhammad is a dodo bird in this scenario. Excerpt from that. Page 6 of the judgment contains the following finding. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent got records from all Michigan Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This finding is not supported by admitted evidence. Page 6 of the judgment. What do you mean it's not supported by evidence? There is evidence that she didn't go to those places. And that all of a sudden, on the day of trial, she says, I went to Los Angeles. So, yeah, it is supported. Page 6 of the judgment contains the following. The court was not provided with evidence of the positive COVID test, but maintains the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. This finding is not supported by admitted evidence and further reflects the court did not properly consider or weigh all the admitted evidence. Specifically, the court assumed, without any basis for doing so, that a visit to the emergency room was the only proper response to the events that occurred on July 23rd, 2023. There was no admitted medical testimony to support the speculative conclusion. The court asserted further ignores the fact that Laura was considering terminating the pregnancy via medical abortion, in which case care for high-risk pregnancy was entirely unnecessary. In July of 2023, she wasn't doing that. Yeah, and you would go because you were trying to do all this other stuff, right? Like, if you're not planning on keeping it and you're not planning on caring for it, why are you going to court for child support? It makes no sense. Page 7 of the judgment contains the following: petitioner admitted to changing an HCG test to reflect. Yes, that number was wrong. We pointed that out. This finding is not supported by evidence. Page 7 contains the 1 and 2. That has to do with that. Yeah, both of those are correct. Just like the date of the May 20th thing. The second sentence of the finding is not supported by evidence. Page 7 of the judgment contains the following: upon denial of her request for medication, however, she did not file a motion to dismiss or make other arrangements to advise respondents of this development. Yeah, she didn't. Finding is not supported by admitted evidence and is directly contrary to the undisputed facts. Ms. Owens, through counsel, filed a motion to dismiss with prejudice on December 28th. Yes, but she did not do that when all this happened. She did it like 2 months later or a month later. Page 7 of the judgment contains the following finding: the court finds testimony uncredible and a misuse of judicial resources. Uncredible is not a word. Okay. And to the extent the misuse of judicial resources finding referred to immediately preceding finding that Laura, she did not file a motion to dismiss to make other arrangements to advise respondent of the development. The finding is not supported by admitted evidence and ignores the fact that Ms. Owens could not advise respondent of the development because he had blocked her ability to communicate with him, and moreover, respondent had sought and obtained an injunction against harassment prohibiting Laura from communicating with him. She knows that she can get that message to him. She could have messaged his attorney. So, no. Nope. Get out of here with that. Page 7 of the judgment contains the following: the court finds failure to seek in-person care for high-risk pregnancy to be unreasonable and uncredible. Uncredible instead finds unreasonable. Supporting is not submitted by evidence based on an application of incorrect legal standard. This is not a negligence case. And reasonableness of Laura's healthcare decisions is not relevant to any issue here. The judgment contains on page 7 following: the court further finds to bear care for a pregnancy test, but not passage of fetal tissue to be unreasonable and uncredible. Uncredible is not a word. And to the extent of court found Laura's conduct to be unreasonable, that is not supported by admitted evidence and is based on application of incorrect legal standard. This was not a negligence case, and the reasonableness of healthcare decisions was not a fact at issue. The judgment contains the following finding: the court finds Dr. Medchill's testimony that 0.1% chance the petitioner received a false positive due to several medications she is in fact taking possible shot for HCG prior. Okay. Established records are given the petitioner testified extensively were not presented to expert. Diminishing credibility are not words. Credibility. What? Now I'm lost. Dimish. I mean, somewhat dim. Okay. Creditability. Credit. Okay, so she misspelled some things. Okay. The finding that Laura had prior history of ovarian cancer is not supported by any evidence at trial. The finding records petitioner testified presented to her own expert for review, and considerations were not supported by an admitted evidence at trial. Yeah, they should have been given to your expert for review. 9, the judgment contains the following. Dr. Mitchell testified that blood Susan Lowell is a lot, and 2 is proof of non-viable pregnancy. The court finds that altering the number to reflect 102,000, so she didn't do that. Okay, that one's right. Page 9, the judgment contains the following findings. Dr. Mitchell concluded she became pregnant on May 20th, 2023, and ended with a spontaneous abortion late October, early November, or possibly sooner in 2023. Given alterations of the only records to indicate pregnancy, the court does not accept this conclusion. The finding that Laura altered the only records to indicate pregnancy misstates the evidence and was not supported by any admitted evidence at trial. Okay. Oh, she's not taking a peace deck as evidence, yeah. Page 10, the court does not accept that a 24-week-old twin fetus would be reabsorbed into the mother's body. The court further finds that miscarriage at the stage of pregnancy would result in an emergency medical care course. Dr. Mitchell testified is true, and she miscarried much sooner, negating the need for the death certificates that petitioner perjured herself at a prior hearing. No aspect of the above finding was supported by any evidence at trial. It was in documents prior to trial that she knows about and watched, and she told people she was pregnant. Then he's talking about she further testified that Planned Parenthood is not open on Sundays. That statement is not supported by evidence. Page 10, judge contains the following findings. After reviewing the records, Dr. Deans determined the HCG tests were never dispositive of pregnancy, and that the related miscarriage timeline, which included detailed analysis of likely origin of HCG and petitioner's blood urine, was not indicative of gestational norms. Emphasis added original. No part of this finding was supported by any admitted evidence at trial. Page 10, the judgment contains the following finding. Petitioner has a prior history of ovarian cancer. It prompted the surgical removal of her ovary. No part of this finding was supported by any admitted evidence at trial. It was in a filing that said what the documents that Owens sent to Maraschini that said these things were sent by Owens. So we have to take those as true because she hasn't done anything to prove that that is not true. Page 12, the judge contains the following finding. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. As to the fact that petitioner admitted to this during her deposition, no part of this finding was supported by any amendment. No, it wasn't done at trial. Page 17 of the judgment contains the following. The court further finds the petitioner repeatedly failed to comply with Rule 49, even on order of this court. No part of this finding was supported by any admitted evidence at trial. Furthermore, the court seems to have completely misunderstood or misinterpreted Rule 49 as requiring Laura to somehow predict information sought by Clayton and then disclose the information without Clayton ever asking for it. If she has information about this, she needs to disclose it. They asked where she got the ultrasound, and she lied and failed to disclose it. In this regard, the court's interpretation of Rule 49 was plain erroneous. As a matter of law, nothing in Rule 49 required Laura to disclose any information about the names of doctors she had seen or medical records of any kind. If Clayton wanted such information, he could have served interrogatories under Rule 60. He requested them and the judge demanded them. Instead, he took the position baseless that Rule 49 required the automatic disclosure of anything and everything Clayton believed was relevant, even if the information was not within any part of Rule 49's disclosure requirements. When she said she got a thing there, she didn't disclose it. Plain and simple. In addition, Clayton's motion to compel was filed on March 10, 2024. In the pleading, he argued that Laura had willfully and wrongfully failed to disclose information pursuant to Rule 49. Yeah. Clayton's arguments were directly contrary to the minute entry order issue of this case on February 21st, 2024, in which the court stated it is further ordered the parties shall complete initial disclosure no later than 45 days from today's date. 45 days from February 21st, 2024, meant that Laura's Rule 49 disclosures were not even due until Saturday, April 6, 2024. Of course, because the last day was a Saturday, that meant per the court's order, Laura's Rule 49 disclosures were not due until Monday, April 8th. See Family Law Rule 4A3. Despite this, Clayton compel was filed nearly a month before Laura's Rule 49 disclosures were due. The motion to compel further falsely stated that Laura had previously made any disclosures at all under Rule 49, a point which was 100% factually false. The finding that Laura repeatedly failed to comply with Rule 49 was plainly erroneous, and the findings in this request was directly contrary to law. Page 18 of the judgment contains the following findings: the court having determined Laura has a pattern of similar, is not identical behavior, and court involvement, this saying there was not evidence at trial. Additional relief requested pursuant to family law rule. Laura further requests that he following prior orders be vacated. January 24th, order granting motion to amend. February 14th, 2024, all baby's due date, order denying Laura's motion to dismiss. All she got denied by everything. April 3rd, 2024, order denying Laura's request for extension of time to respond to Clayton's motion to compel. April 9th, May 1st, 2024, order denying Laura's motion to compel lunch. May 22nd, order denying motion to strike and motion to eliminate. May 29th, order denying Laura's motions for judgment on the pleadings. Thank God we're on the last pages. First of many of the trial court's orders granted relief in favor of Clayton, i.e., his request for leave to amend and his motion to compel. But substantially every instance, Clayton's counsel filed those motions without making any attempt to meet and confer as required by Family Law Rule 9C. Compliance with that rule is not optional, but Mr. Woodnick repeatedly ignored it with any basis. I believe he has talked to you through email, maybe through text, and probably on some phone calls. I don't think he has to be in person with you. Mr. Woodnick further filed a motion to compel, which did not contain the good faith consultation certificate required by Rule 65A1. And incredibly, the motion to compel did not ask for an order requiring Laura to respond to any specific discovery request because no discovery request had been made regarding the information sought in the motion. Incredibly, the motion to compel was solely based on Laura's alleged failure to disclose Rule 49, but the information sought, records from third parties, was not subject to any aspect of Rule 49's disclosure requirements. As noted above, the motion to compel also contained knowingly false and fraudulent statements of fact and omissions, including 1, a statement falsely claiming Laura had willfully and wrongfully failed to disclose information pursuant to Rule 49. Well, that was proven at the hearing trial. She willfully and wrongfully did not disclose Planned Parenthood Los Angeles, which that's not even true either, but still. 2, an intentionally deceptive omission which failed to remind the court that per the court's minute entry order issued February 21st, 2024, Laura's initial Rule 49 disclosures were not due until nearly a month after the motion to compel was filed. These knowingly false representations and omissions by Clayton's counsel constituted fraud sufficient to entitle Laura to relief pursuant to Rule 85B3. Okay, we'll take one of the charges that Clayton had off to the person. Okay. In short, assuming this matter is assigned to a new judge, all orders issued in this case by should be vacated on the basis that they were improperly without a legal basis. Often direct disregard for rules of procedure by a judge with not only significant bias but strong personal animus towards a party, which was unfortunately not possible to prove until just days ago. Finally, pursuant to Family Law Rule 35A2, Laura respectfully requests to leave to see the 17-page limit of that rule. Good cause exists to submit a longer brief due to the large number of areas issues discussed above. This is particularly true because as a Laura cannot raise arguments for the first time on appeal, and most through not all of the problems described above occurred in such manner, i.e., post-trial, and Laura had no prior opportunity to present and preserve his objections. Conclusion: for the reasons stated above, Laura respectfully requests an order vacating the June 17, 2024 judgment in its entirety, granting additional relief as requested above, and ordering a new trial before a new judge, signed Gingras on July 12, 2024. Oh my God. Thank God that's over. His good faith consultation and the copies were sent. Okay. That is done. Praise the Lord. I meant to do this in the last live stream, but our quote of the day is going to be bias, like beauty, is often in the eye of the beholder. Facts are your firewall against bias. And who has facts on their side? So when you have the facts, you don't have to worry about bias because you have facts backing stuff up. You can sit here and believe all you want to, that they don't like you, they didn't do this properly, whatever. You can think that all day. But the facts of the matter are that Laura Owens has lied, has perjured herself, has submitted fake evidence, and so much more to multiple men. So I don't think it's bias, because anybody that comes into this not knowing anything, they learn the facts of the case. That is not a bias. They formed their opinion based on those facts. If you had different facts, maybe it would be different, but you don't. The facts are the facts. Just because you don't like them, it doesn't mean they change. That is going to be it for tonight. Thank you for suffering through this with me. I will put out a video the attorney's fees just to have it in our playlist so that we have all the coverage of this case in one location. We still have more to discuss in the Sandra Birchmore case, so that will be coming up as well. But other than that, I hope y'all have a good evening. I am going to go to bed because it is bedtime.
Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. Sparking revolution, it's a truth-telling tale.